Very good evening to everyone. And my microphone is a little unsteady. Some people might still be coming in, but I suggest we start because we have quite a full agenda for this evening with many brilliant speakers. So I don't want to take too much of the academic five before we start. My name is Gabriel Chlevskaite, and I'm a researcher in international criminal law here at the After Institute. And it is an honor to welcome all of you here this evening. Actually, a beautiful June evening, so I really appreciate that you took the time to come and join us for this really interesting and promising panel discussion on legal developments and accountability efforts for the crime of aggression committed against Ukraine. This event is part of our Benjamin Ferencz lecture series, previously known as Supranational Criminal Law Series to many of you, especially the ones who've been in The Hague for a while. And it has been organized by the After Institute since 2003, together with a coalition for the ICC and the Grotius Center for International Legal Studies at the Leiden University. Some of you may have heard of, seen online, or may have even been here in September 2023, when the Institute hosted a panel discussion to examine the legal case for prosecuting the crime of aggression against Ukraine. The idea of a special tribunal was just taking shape then, and now at a critical moment, we return to take stock and look forward with a brilliant panel of experts. What was discussed in September 2023, and for those of you interested, there is a video online that you can find of that discussion. The lacuna for prosecution of those most responsible for the crime of aggression, including the limited jurisdiction of the ICC and the urgent need to amend the statute, the immunities that are applicable for state officials in foreign domestic courts, combined with a consensus that impunity for such actions cannot be the norm under international law, still stand today. But the conversation has moved much further, as our panelists will shortly introduce. We have not just ideas about special tribunal, but concrete steps towards its establishment. And it is a result of concerted effort and work that has been carried out in the previous years, some in the public eye and some behind the scenes. I'm again thrilled that we're able to bring together such an excellent panel to explore some critical questions. But before I turn to the panel, I'm especially honored to welcome His Excellency Mr. Andrij Kostin, Ukraine's ambassador to the Netherlands and permanent representative to OPCW, to provide some reflections and set the tone for our discussion. Please, you have the floor.
Distinguished colleagues, ladies and gentlemen, friends, it's an honor for me to address you today in The Hague, the global city of peace and justice, and true capital of the international justice for Ukraine, on the matter of immense urgency and moral clarity, ensuring accountability for the crime of aggression committed by Russian Federation against Ukraine. But first of all, I would like to thank After Institute for organizing this important and very timely event. Of course, following the previous discussions, which definitely played a role in order for the Special Tribunal to take a shape, as Gabriel mentioned. Today, I speak not only as a representative of a sovereign nation under brutal attack, but also as a citizen of Europe, a continent whose post-war architecture was founded upon the promise of never again. Yet, that promise has been shattered. Russia's full-scale invasion of Ukraine, launched in February 2022, is not only a blatant violation of the UN Charter, but also the most egregious act of aggression on European soil since the Second World War. It is precisely this extraordinary situation that demands an extraordinary response. In this context, Ukraine, together with a broad coalition of partners, have recently finalized the preparatory work required to establish a special tribunal for the crime of aggression against Ukraine. And let me be clear, this tribunal will be exceptional because the circumstances are exceptional. And while the core group of states and hundreds of lawyers, publicly seen and those who were behind the scene, worked tirelessly under sometimes political pressure to create, as we always said, a proper tribunal, we established a very important instrument to ensure that preparatory work for tribunal by investigators and prosecutors of 6 countries within the International Center for the Prosecution of the Crime of Aggression in The Hague, here as well, that have undertook this job while discussions on the composition and format of the tribunal were ongoing. The aim of this exercise was to ensure that once tribunal is established, it will have a strong evidentiary foundation to begin its work without delay. And this is how Ukraine create very special type of modern diplomacy when we try to do in parallel steps of the process, which in classic way is made by consequent actions. Because we understood that we will have decision, the political decision, the legal decision on the special tribunal. We understood, we believed in it. And we shared this with all of our partners and friends, and even with those who were opposing. But we knew that it will be established. And we understood that if and when it will happen, then, of course, preparatory work made by the prosecutor of this tribunal and his or her team will take time, maybe years. But our commitment was always to deliver justice in time for people who suffer, for people who lost their beloved, for our servicemen and servicewomen who suffered from this war, for our civilians, children, elderly, all those who suffered personally, physically, mentally, all those should know that we together are doing our best to ensure justice delivered in time, not to wait for 10 or 15 years, not to wait until war will be ended and then start to collect evidence. So the idea was to collect evidence and to prepare everything in parallel. And I think this approach will bring fruitful results because the work of our colleagues at the ICPA is really a preparatory work for the future tribunal. We are not inventing, coming to the tribunal, something unprecedented. We are restoring the principle that no one is above the law, including the highest political and military leadership. We are drawing on the legacy of Nuremberg and Tokyo, not to repeat the past, but to protect the future. With all the amount of work already done, still a lot is ahead. The tribunal must become reality as soon as possible. Our people's faith in international justice depends not only on principles and processes, but on results they can see and feel. Sorry to say it now, while they are still alive. Justice, again, must be timely, not abstract. In this regard, I would like to underscore the exceptional role of the Council of Europe in this process. Its political, legal, and institutional weight is harnessed to support the establishment of the Special Tribunal. I would also like to underscore that the tribunal is an essential element of Ukrainian doctrine of comprehensive accountability, which we name the web of accountability. We work hard on addressing the full spectrum of international crimes committed during Russia's war against Ukraine, both at national and international levels. And we will have a lot of such meetings and discussions here in The Hague related to all of the elements of this comprehensive doctrine. And here I'd like to reiterate Ukraine's gratitude for the strong support we receive from the Kingdom of Netherlands, from Eurojust, from European Commission, from all the countries and members of the core group of states who discussed the future tribunal and its format, and for all legal scholars and academia who helped us to find a common solution in a very new, unknown, unclear for someone situation when we started this. They have proven, our partners and friends in justice, they have proven that there is a strong commitment to ensuring full accountability for the crime of aggression committed by Russian leadership, as well as for all international crimes and atrocities committed by Russia in Ukraine. I believe that we also should acknowledge that one lesson for the future is already evident. There is a need to re-examine and modernize the norms of international humanitarian and criminal law. These bodies of law must evolve to address the realities of today's wars and conflicts, and to ensure that impunity does not flourish in legal gray zones. Justice must be pursued not as an abstract value, but as an operational goal. It must serve also as deterrent, and it must stand as a warning to those who believe that power can overrule principles. Thank you, dear colleagues and friends, and I wish you success in this event. Thank you.
Thank you very much, Ambassador. I think we share your commitment to international law being something operational rather than just something that we talk about in this room. I would now like to give the floor to our long-term partners, supporters, financial contributors to our work, the Ministry of Foreign Affairs of the Netherlands. And with us today, we have a Senior Legal Officer of International Law Division at the Ministry, Elke Koning. So, Elke, please, you have the floor.
Yes, good evening. Your Excellencies, dear André, distinguished panelists and guests. I am the coordinator for accountability for Ukraine at the Ministry of Foreign Affairs. I am no legal scholar, but I'm happy to see that we have a very distinguished panel here of geniuses in their own right. But I believe as well that international criminal law is an operational issue, and therefore something that also we as a Ministry of Foreign Affairs have taken forward as one of our assignments, really. So as the coordinator for accountability for Ukraine at the Dutch Ministry of Foreign Affairs, it's really an honor and a pleasure to be here with you today, to be able to say a few welcoming remarks. I'd like to thank the Asser Institute for organizing this event on this important topic, the crime of aggression. And this event, as you mentioned, Gabriela, is part of our close cooperation on ensuring accountability for the crimes committed against Ukraine in the context of Russia's aggression. And we are working closely together with many of you on restoring justice for Ukraine. As the ambassador said, it's a collective effort. We have worked closely with you, Ambassador, actually also in your former role as a Prosecutor General of Ukraine. And I'm very pleased to have you with us now as our ambassador, somebody with such a distinguished career, such a profound understanding of the issues. And as you have already had the pleasure to experience, a very eloquent speaker as well. It's always a hard act to follow. It's good that you're here with us in the City of Peace and Justice. And I would really like to underline how much we together have been able to achieve in these last few years. And I'd like to especially take this opportunity to commend our Ukrainian colleagues in Ukraine, as well as here in The Hague, as well as on missions around the world. You have shown tremendous dedication, professionalism, and resilience under the direst of circumstances. We are here to say we see you, we appreciate you, and we support you. and we will continue to support you in the years to come. Since the start of the unprovoked, illegal, large-scale invasion of Ukraine by Russia, we as an international community have rallied and come together to aid Ukraine to resist Russian aggression. And we have rallied to restore justice for Ukraine. Justice for the crimes committed and justice for the damage sustained as a result of these crimes. It is because of all of our combined hard work that we are where we are today. Jointly, with lightning speed, I might add, we have established a register for damages for Ukraine here in The Hague. It has been operational since April last year. It has received thousands of claims already from ordinary Ukrainian citizens, from businesses, people that have sustained damage as a result of Russia's invasion. And currently, we are in the process of negotiating a claims commission, a commission that can adjudicate all of these claims. We expect to be able to hold a treaty conference by the end of this year. And jointly, we have established the International Center for the Prosecution of the Crime of Aggression here in The Hague. And they, including Miroslava, have been working tirelessly on collecting evidence that can be used by national and international courts. And we have made progress on a tribunal against aggression. As early as March 2023, we heard calls for the prosecution of the crime of aggression against Ukraine, to hold President Putin to account, to defend the prohibition of the use of force, a principle that underpins our international legal order, and to bring justice to Ukrainian citizens. For this, we needed an ad hoc tribunal because, as was already mentioned as well by Gabriele, the International Criminal Court lacks jurisdiction over any crime of aggression involving a state not party to the Rome Statute, but also because Ukraine cannot take on this immense task by itself. And the value of prosecuting this aggression cannot be overstated. Failure to secure meaningful accountability for Russia's crimes in Ukraine will only serve to embolden the perpetrator. It will inspire other authoritarian states to undertake similar actions. It will ultimately and inevitably make all of us less safe. But let's be very clear about this. Holding Russia's political leaders to account is also a challenge. There are different ideas about what the modalities should be for such a tribunal and what it should look like, what the mandate should be and what it could be. And after 2 years of talks, under the excellent leadership of Ambassador Anton Korinevich, who will be speaking to you shortly as well, we have reached a legal compromise. And I'm sure you will discuss here today the merits of this result. But I personally, having worked on this for the last 2 years, I feel that what we have achieved is a good result, a result we can be proud of, all of us, given the challenges that we had to overcome. However, now comes yet another challenge as our discussion moves from the technical to the political. And we work to establish a tribunal with the Council of Europe and make justice a reality. We are in a moment of international political uncertainty. The ICC is under duress. Safeguarding the international legal order and the legal framework of criminal justice is of paramount importance. Now it is up to all of us here, all of us in the international community, to secure sufficient political and financial backing for the establishment of a credible and effective tribunal, a tribunal that can deliver results. And we cannot, in this, let short-term thinking take over. We cannot fail our collective duty towards Ukraine or the international legal order. We need to send a very clear signal that there can be no impunity for the crime of aggression. I look forward to our legal discussions today. And in the meantime, the Netherlands will continue our political, legal, and practical efforts to establish this tribunal, to make it a reality for the citizens of Ukraine. Thank you.
Thank you, Elke, for setting the tone for the legal discussion. Now that we are a little bit more warmed up, I would like to introduce our panelists. And before we begin, just to note, I will share very condensed versions of people's bios, just to maximize the discussion time and that we can go into all the topics. So starting with experts joining online, can we have them on the screen? Anton, Katerina, can you hear us? Hello. Hi, both of you. So we have with us Dr. Katerina Busol, who is an associate professor at the National University of Kiev Mohila Academy, a British Academy Research Fellow at the British Institute of International and Comparative Law, and a legal advisor to the International Center for Transitional Justice. Her expertise spans conflict-related sexual violence, cultural heritage crimes, and Ukraine's transitional justice process. She was also previously fellow at Chatham House and a visiting professional at the ICC Office of the Prosecutor. Welcome, Katerina. And as aforementioned, we have with us also Dr. Anton Korinevich, who serves as Ambassador at Large and Director for International Law at the Ministry of Foreign Affairs of Ukraine, and specializes in public international law, international criminal law, and international humanitarian law. He represents Ukraine before the International Court of Justice and arbitral tribunals and was the chair of the core group on establishing the Special Tribunal. He's also associate professor of the International Law Department of the Institute of International Relations of Taras Shevchenko National University of Kiev. Welcome, Anton, and thank you for being with us. Just turning to the experts in the room, and I'll go to my right, we have Professor Frank Hofmeister, who is the head of the legal department at European External Action Services and professor for EU External Relations Law in the LLM in International and European Law program of the Brussels School of Governance, has vast practical experience in various sections of European Commission, serving on Cyprus desk, member of the legal service and deputy head of cabinet of the EU Trade Commissioner and head of unit for trade defense. And as I said, I am making these bios slightly shorter. And Miroslava, always good to have you here. I think a common guest at the ESA Institute is liaison prosecutor for Ukraine at Eurojust, just around the corner. Previously, she served as deputy head of Department for International Legal Cooperation and head of division for international cooperation of the Prosecutor General's office in Ukraine. And in these roles, she specialized in the transfer of criminal proceedings, mutual legal assistance, asset recovery, international cooperation, and the negotiation of international treaties. And last but not least, and furthest from me, we have Professor Karolina Werczynska, Associate Professor at the Institute of Law Studies, Polish Academy of Science, Chair of Public International Law. She's also the Director of Center for Research on International Criminal Law and the Deputy Editor-in-Chief of the Polish Yearbook of International Law. Currently, she is a member of the Polish Foreign Ministry's Advisory Board on questions of international law. And now that I have thoroughly tested your patience with the introductions, I think we're more than ready to hear what our guests have to say. So the panel discussion will be opened by Dr. Korinevich, who will set the scene on the Special Tribunal for the Crime of Aggression, the work of the core group, give us insights into the developments over the last year and where we are now. Please, Anton, you have 10 minutes. You have the floor.
Good evening from Kiev, dear colleagues, dear panelists, dear audience, dear Gabriele. It's a big pleasure and honor to participate in today's very important discussion, and I'm really grateful for the Arthur Institute for organizing this important conversation, and it's really a privilege and honor to participate in the discussion after the opening remarks by Ambassador Kostyan, dear Andriy, and dear Elke. And with such a great panel of people, a lot of us invested a lot of time and efforts to be where we are in terms of the special tribunal. So I will really try to briefly speak of what we did within the core group, where we are now, and what are really the next steps, which actually Elke was talking about, that we are moving from this legal work to the political work, and this means that we need to keep being mobilized and to get the work done. As you all know, since the very start of the full-scale invasion of Ukraine by the Russian Federation, we started to think how we can deal with the task of establishing the Special Tribunal for the Crime of Aggression against Ukraine. So it was a matter of, and it is a matter of big priority for us within the concept of comprehensive full accountability, web of accountability mentioned by Andriy. And it is the understanding of everybody here in Ukraine, government officials, civil society leaders, experts, that without accountability for the crime of aggression, we will not be able to tell our children, our compatriots, that we actually did what we could do in order to ensure accountability for all the horrific Russian crimes committed here in Ukraine, because it was a crime of aggression. because of which everything started. Because if it wasn't crime of aggression in 2014, there wouldn't be any single war crime committed by Russians on our soil. So that is why it is really important for us to tackle this original sin, this primary crime. But of course, we understood that it wouldn't be an easy task, since establishing a new mechanism within the international arena, it's always a hard task. Moreover, it's even harder task when we talk about the crime of aggression. Somehow, I think we can call it enfant terrible of international criminal law, due to the rise of the importance of the crime of aggression as crimes against peace after the Second World War, and the decline of the interest of international community to ensure accountability for the crime of aggression in the years to come, effectively because of the political positions of some governments. And it was also understood for us that this work cannot be done solely by Ukraine, and we need to invent some kind of a platform mechanism which will enable us to do the job. So that is how the idea of establishing a core group emerged. And we tried to do everything possible, and I think we succeeded in it, that we established a core group as a very, I would say, easy mechanism, easygoing mechanism, very, I would say, not strict mechanism, informal, which would enable legal advisors of our participating states to participate in the core group and to contribute to the discussions and to the result. So I believe that choosing of this informal format was really very important, and the creation of this atmosphere of working together, of understanding that what is being there in the room stays in the room. I think it was really a very important instruments of building trust and confidence inside the core group. The core group started to work in the end of January 2023. We held 14 expert meetings in many places throughout Europe, in particular in The Hague as well. And we finalized our job this March in Strasbourg. And I think it's also important that the finalization of the work of the core group happened in Strasbourg, as now we are talking about the establishment of the Special Tribunal within the framework of the Council of Europe. So what we did throughout this more than 2 years, we really tried to figure out how to establish the Special Tribunal in such a way that everybody in the room within the core group will be able to live with the result. I think this formula is really very important. So we are not saying that this tribunal could have been ideal. Nothing would be ideal, I believe, in the current circumstances within the international legal order. But the tribunal which would be effective, which would be feasible, and which would be supported by our international partners, including by those who participated in the core group. And I think that back then in March this year, we finalized the 3 drafts necessary for the establishment of the tribunal: draft bilateral agreement between Ukraine and the Council of Europe, draft statute of the Special Tribunal to be annexed to draft bilateral agreement, and also draft enlarged partial agreement on the management committee, which would deal with the functioning and financing and administering the work of the future Special Tribunal. So in March, we finalized the legal background. So the legal work is done. Legal teams did their job. And now we really work on transferring these legal results to the political scene. How we do this? So we made already several important steps, which I want to emphasize here within the time which I have. So first of all, we had an important ministerial core group meeting on the 9th of May in Lviv, which is a very important city for the contemporary international law because of the input by its heritage of the people who lived and studied in Lviv, like Raphael Lemkin, Hersch Lauterbach, Louison, and others. And in Lviv on the 9th of May, ministers of the core group made public support and made it in a public way, that the core group, by its ministers of foreign affairs of participating states, support the establishment of the tribunal, and we adopted the relevant leave statement on the support of the establishment of a special tribunal. So this was the first moment of transferring legal work to political scene, since before that we didn't have any kind of political engagement or political backing of the special tribunal. Then on the 14th of May, the very important, both I would say legal and political thing happened. Ukraine submitted a letter signed by Minister of Foreign Affairs of Ukraine, His Excellency Mr. Andriy Sybiha, in the name of the Secretary General of the Council of Europe, Mr. Alain Berset, with a request to establish a special tribunal. And this letter was accompanied by 3 drafts, worked it out and produced within the core group: draft bilateral agreement, draft statute, and draft enlarged partial agreement. And after this moment was very important and crucial one, because this was a moment of transferring the work of the core group to the Council of Europe framework. So now the work is in Strasbourg, and we are really looking forward to see active, effective, and fast-track work of the Council of Europe in this relation. And it is very important that just today this question was discussed on the meeting of the Committee of Ministers of the Council of Europe, and they already drafted a roadmap or a scheme how to proceed with this task, in particular by establishing a working party which should work on this issue on 3 drafts by 9th of July. We of course wanted it to be faster, but 9th of July is still a good timing, months from today. And then to decide when the draft bilateral agreement between Ukraine and the Council of Europe can be signed. So now we depend on Strasbourg procedures, but I believe that we, together with our international partners and friends, we will do everything possible for these procedures to be as fast and as effective as possible. On our side, we, Ukraine, are ready to sign the bilateral agreement between Ukraine and the Council of Europe as soon as possible, without any delays, as soon as the Committee of Ministers of the Council of Europe would authorize the Secretary General of the organization to sign the agreement with Ukraine. We also, of course, are in contact with our parliamentarians for them to be able to ratify the agreement as soon as possible, as soon as the signatures are there on the agreement. So we have the track, we have the road, and we will do everything possible for it to finalize with the establishment of the tribunal. And in the very end, just very quickly, I would, of course, say that this all would have been impossible without the support and active engagement and dedication of our friends and partners. A lot of them are there in the room today in The Hague. Elke, Frank, Andriy, many of you there. And I'm sure that this is not only about the work and the obligations which we all have as servants. This is also about dedication and passion to international law. The understanding that if this crime of aggression is not tackled, and if accountability for this particular crime of aggression is not ensured, then what is crime of aggression? Then whether the fundamental principles of international law exist at all. So I think this is really the moment of truth for many of us who believe in international law. So many thanks to all of you who support the effort. The road is not finished yet. We have a lot of things to do, but we already have the background, which is good for the effective tribunal's establishment, and for us all, as Elke mentioned, to be proud of what we achieved throughout these 3 years. Thank you.
Thank you, Anton. Thank you, Anton. Always a pleasure. Thank you for your excellent overview and truly personal insights from the eye of the storm. I will now turn to Professor Hofmeister to present the aforementioned mystical so far Council of Europe Ukraine model. Just over to you. I'm not going to take any of your time. You have 10 minutes.
Thanks a lot, Gabriele, and it's a pleasure to speak after Andrei Kostin, Elke Koning, and Anton Korinevich. I was now giving the task to explain a little bit the legal content of the Council of Europe model. The text is not yet public, but the working assumption is that it will be published very soon when the Council of Europe process is going to be started. So I take a bit the liberty to explain to you the main features of the core group draft. So legal basis, Anton already mentioned it. There will be an agreement between Ukraine and the Council of Europe as such. Yeah, the international organization of the Council of Europe and Ukraine. That's important. And some have asked, okay, where's the treaty-making power of the Council of Europe for that? And the answer is it is possible for an international organization to conclude treaties within the realm of its functions and powers. We are here in a situation to restore justice, and we are in an international rule of law context, which is part of the objectives of the Council of Europe. So treaty-making power is there for the Council of Europe to support Ukraine in its endeavor to bring those responsible for the aggression to justice. So that's the very first and important moment to understand. Second is, what does that mean for the members of the Council of Europe? If I'm a member state and I'm not so happy about it, does it bind me? Do I have to be part of the exercise? The answer is not really, because this is an area where the Council of Europe itself has no power to impose obligations on its members. Therefore, the fact and the effect on the members of the Council of Europe will be regulated in the second text, which Anton already mentioned, and that's the enlarged partial agreement. In other words, all those in the Council of Europe who want to support the tribunal will conclude a second text, and in that second text, they will then express their commitments to finance it and to be part in the management of the tribunal and so on. And I just said enlarged partial agreement. Why enlarged? Because it is also open for non-Council of Europe states. In other words, our friends from Canada, Australia, and others who are and were very constructive in the core group can also join the EPA. And then we have a web of states who will then actually be at the heart of the support structure. This is, I think, a very important point to make. Third issue with the legal construction is, will an EPA member have a duty to cooperate with the tribunal? And here also the lawyers have to say, what is then the legal quality of such an EPA? Can it impose binding obligations of cooperation? That was not so easy to reply, and therefore the core group said, well, we want to have also very clear-cut cooperation agreements between the supporters and the tribunal as such. And for that, the Netherlands was in the lead to come up with a draft model cooperation agreement between those, how to say, who are not sure whether the EPA as such can produce such a binding effect, and therefore this will also be part of the construct. Now, turning to the tribunal itself, we have heard that it, of course, responsible for the crime of aggression. And that means it will be responsible to judge those responsible, which is a leadership crime. So military, political leaders who have committed aggression against Ukraine. So far, so clear. But how do you define that legally? What is the yardstick? Is it the Ukrainian domestic law, or is it international law under the Rome Statute, or is it a mix or something? And depending on where you come from, you have different answers. And at the end of the day, core group made a very wise decision and said, look, on the one hand, we take the definition of the Rome Statute, Article 8 bis is the aggression. But in this definition, it says an aggression is something which is also a manifest violation of the UN Charter. And that opens theoretically a lot of discussions. What is it? How far can it be? Some may think it's maybe too broad. And then you can conceptualize it, and you can circumscribe this and by saying, well, in order to find whether or not you have a manifest violation, let's look at the relevant UN General Assembly resolutions on Ukraine. And those are then referenced in the preamble and in the statute itself, so that we have a contextualization, not an open-ended kind of exercise. And with this, everybody was happy in the room to apply Article 8 bis, as it is the most recent and therefore also the most important definition on the crime of aggression. About the organization, I can be very brief. This will be following relevant precedent. So we have an independent prosecutor, we have the judges as such in pretrial chambers and appeals chambers, and there will be an independent registrar with a defense unit and so on. So this follows established practice. Important is a judge will be assigned to the case from a roster. So we don't know in advance how many cases at what time will be pending. Paying judges for doing nothing is not a very good idea. So you better have them activated when there are precise cases. This has been done in the Kosovo specialized chambers, and it is in line with the rule of law on the independence of judges. So that's maybe an important point. One, languages. Yeah, what is the working language of the tribunal? If it's in the Council of Europe, some people will say, well, it needs to be English, French, Russian, Ukrainian, and what have you. Again, this will be enormous amount of money to be spent just on translation. In order to be efficient, it's better to stick to English as a working language, and the others only if it is absolutely necessary, also to make this swallowable. Okay, I leave it at that on organization. Now, proceedings. There is a big question was, how can a case come to the tribunal? Is the independent prosecutor, can it prosecute whatever he or she thinks, or do we need to have some connection to pre-existing instruments? And here, Andrei Kostin, the ambassador, has already said very clearly, we have tried to save time by establishing the ICPA. Miroslava will say more about it. So it is imperative to use all the material that is currently already there in the ICPA. And it is also important to use the material that the prosecutor himself has collected. Over, I don't want to get the figure wrong, but a very, very big amount of war crime cases, but also some aggression cases are pending in Ukraine, and there should be some sort of link with the tribunal. And therefore, it is possible that both ICPA and the prosecutor may refer this kind of material to the prosecutor of the tribunal, and then the prosecutor of the tribunal will make his own independent assessment and bring the case forward. Yeah, this kind of link is, I think, an important part of the construction, and is also under constitutional law of Ukraine important for the parliament to understand. Ukrainian parliament will understand. We are giving a little bit from our domestic jurisdiction to this tribunal, but we will ratify this. I mean, we are giving our consent for this kind of operation. The trial and the investigation itself follows established practices. There will be a question of what happens if the person is not in The Hague. So do we have a possibility to go ahead with so-called trials in absentia? For many states, this is not ideal, but it has to be said, this is in line with international human rights law if you have procedural safeguards. And what we did is to look very precisely at the jurisprudence of European Court on Human Rights, and then distill the procedural safeguards out of it, and also to pay tribute to the fact that in Ukraine itself, trials in absentia are possible. Would be very difficult to explain to someone that, okay, if the person is tried in Ukraine, he doesn't have to be there, but if it goes to The Hague, the person needs to be there. So that would be some sort of an imbalance, and therefore, after considerable discussions, core group agreed, yes, trials in absentia are possible with the rule of law safeguards, in particular, a full right of retrial if after the sentence the person all of a sudden appears and contests. Yeah, then the person may ask for a retrial. And another important point also mentioned was ICC. So what's the relationship with the ICC? What happens if, for example, the same person is indicted in both? Yeah, we know there are indictments against very high representatives of the Russian Federation already ongoing. And do then the two tribunals compete against the same person, or how should it be regulated? And the idea laid down in the statute is to say, well, there is a duty of mutual cooperation, so ICC and the Special Tribunal should make an effort to somehow compartmentalize the work. But if a person who's under indictment in the ICC is physically in The Hague, yeah, is in detention in The Hague, then the case in the ICC should take precedent. Yeah, so this is also a good way to avoid what one would say unnecessary judicial competition. And final point, victims' participation. I know that for Katerina, this is a very important point, which she wrote a lot about it. In the core group, we had quite some exchanges. How is it possible to define the victims of the crime of aggression, and how can such victims participate in the case? And there were quite different views about it. I cannot go into detail, but the solution at the end was to say, well, it's not excluded that there are specially affected groups which could be victims of aggression. But if they are specially affected groups, they should be represented by a lawyer. And the lawyer then has to represent the common view of those victims' groups. And the judge can always say, well, I need to make sure that the administration of justice works out. So if I get too many of those and then the case gets undigestible, I have to put some sort of a caveat into it. Yeah, but the principle of victims' participation is accepted with these kinds of guarantees that it will be group participation by lawyers, not affecting administration of justice. So I think in my 10 minutes, these are the main issues from the core group draft. I will come to conclusion. I think personally also for the European Union, we were very actively there and tried to propose good and sound solutions. We are, like Elke, rather proud about it and think that's a sound legal outcome. It has some novelties in it, but it is up to the challenge, and it is an international effort to support Ukraine. Thank you.
Thank you, Ambassador. Thank you, Frank, for giving us more crucial insights and more of a sneak peek into the preparatory work and what we have that's still under wraps. But there is more to unpack and more aspects of the tribunal and this accountability process to unpack. I'm sure that what many of us, at least from the legal field, now have on our minds is how the tribunal will function with the immunities for foreign officials in place while aiming to hold those most responsible accountable. Professor Wiercinska, could you perhaps help us better understand what do functional and personal immunities mean in the context of proposed tribunal jurisdiction, and what do you foresee as challenge?
I will, of course, try. Thank you very much for invitation here. I will start with that since the launch of Russia's military invasion of Ukraine in February 2022, there have been growing calls in Ukraine and internationally for the prosecution of the crime of aggression. But this aggression gap, or this inability of the ICC to prosecute Russian aggression in Ukraine, has led to calls to create a special tribunal for the crime of aggression. just to fill this lacuna, this underscoring the ICC's current limitations, we already know that such tribunal will be created as model based on this agreement with Council of Europe. And in such a moment, when we are taking the crime of aggression as a context, it is necessary just to discuss this question of immunities of those who will be prosecuted before such a court. Taking as a point of reference the definition of aggression from the Rome Statute, because this is a point of reference for this core of group definition, it must be noted that aggression, and it was noted, that aggression is a leadership crime. So it only a narrow circle of officials beyond the troika could be actually responsible for aggression. At the same time, those officials may, in principle, enjoy the functional immunity, and they will claim that functional immunity actually prevents their prosecution. And Troika will additionally enjoy personal immunity, what means absolute immunity at the time of holding the office. In the dawn of history, immunities were conceived to protect envoys. Their purpose wasn't to shield the individual from the responsibility, but rather to protect official acts and rather to protect international relations. And today, it seems that we gravely misunderstood the idea, allowing individuals who have committed international crimes to be protected for life. At this point, I will briefly explain doubts to facilitate understanding the problem. In customary international law, a distinction is made between immunity ratione personae, I mean the personal immunity or procedural immunity, and immunity ratione materiae, which is called functional or material immunity. The personal immunity concerns the protection of high-ranking state officials, and it is considered the absolute immunity during the term of the office, while the functional one concerns the performance of state functions by state officials. And in this case, there is a growing tendency of recognizing that this immunity cannot actually constitute an obstacle to the prosecution of a person who allegedly committed international crimes. And the recent surrender of to the ICC of the former president of Philippines, Rodrigo Duterte, indicates the acceptance of this state of affairs in the context of ICC proceedings. So this absolute nature of personal immunity means that it prohibits to exercise criminal jurisdiction over the person, including the official and private acts of this person. And even ICC confirmed, under international law, a sitting head of state enjoys personal immunities from criminal jurisdiction and inviolability before the national courts of foreign states. But of course, this validity of immunity is strictly linked to the period of holding office. And actually, this personal immunity cannot exonerate the person concerned from the criminal responsibility if that person committed international crimes. The International Court of Justice confirmed that such a person could actually be held accountable by an international criminal court. And it was actually confirmed also by other international tribunals and the doctrine. So, nevertheless, this status of immunity ratione personae raises a lot of doubts, especially in the context of ICC proceedings. The problem lies in surrendering nationals of non-state parties to the court. And without into the complexities of this tribunal's jurisprudence on this matter, I will just leave it for the later discussion. Anyway, among the international criminal tribunals established after the war, the regulation in Article 27 of the Rome Statute of International Criminal Court is the most advanced because it says that immunities or special procedural rules just shall not bar the court from exercising its jurisdiction over the person who committed international crimes. And state parties to the statute of the ICC, they were fully aware of the regulations contained in the statute, so they knew the scope of their obligations. As the result, those state parties cannot refuse to arrest and surrender the head of state of another state party on the grounds as they are protected by immunity. So, according to the regulations of Article 27, since no immunity can be an obstacle to proceedings before the ICC, the state party is obliged to fully cooperate, and there is no exception to this cooperation. As the result, it should unconditionally to arrest and surrender and should just execute this arrest warrant issued by the tribunal. And now I come to this definition of aggression, because this is clearly visible in connection with the tribunal's jurisdiction over the crime of aggression. Since, as mentioned, this is a leadership crime, it concerns only the perpetrators at the highest level of official hierarchy, protected by immunities. But recognizing that such a person cannot be brought before the tribunal because this person is protected by immunity would make it impossible to prosecute the crime of aggression at all. And clearly, it was not the intent of the drafters of the statute and the drafters of the definition of aggression, because the court was meant to be effective and not limited by any obstacle of personal immunity. At the same time, the ICC is blocked by the stringent jurisdictional regime over the crime of aggression, while national courts' jurisdictions are restricted by immunities enjoyed by state officials, what makes prosecuting of aggression almost impossible. And here I would like to refer to this draft of the core group, because I would like to observe with you whether the drafters took into account those lessons from the ICC. So Article 4 of the draft deals with the criminal responsibility of individuals who are not shielded by their official position or any amnesty granted by their state of nationality. So we can observe here this principle called irrelevance of official position. It is taken, for example, from Nuremberg Charter or from the Statute of International Criminal Tribunal for former Yugoslavia. But the draft goes even further, because in Article 23, it divides the types of immunities, functional and personal mentioned a while ago. According to its regulation, functional immunity does not apply before the Special Tribunal. But moreover, the Article 23 also contains the solution concerning the personal immunity of Troika. So the idea is that when there is an indictment of the prosecutor of the tribunal concerns a head of state, the pretrial judge will not confirm the indictment. It will rather suspend the proceedings and until this person no longer holds office or an appropriate waiver has been presented to the Special Tribunal. And summing up this short intervention, I would like to say that either the drafters did not want to prosecute the Troika at all, or the idea was that drafters wanted to avoid this inability of the ICC to prosecute those protected by personal immunity, or maybe both, or maybe they just wanted to balance some interests of justice. Thank you very much.
Thank you, Karina, for squeezing such a complex topic into a short intervention. And I'm sure there's already discussion questions brewing in our heads. And of course, jurisdictional challenges and cooperation have proven to be a major hurdle for international legal institutions. But luckily, some work has already been done. As Elke also mentioned, the ICPA has been established. So I will now invite Miroslava to walk us through the cooperation mechanisms, the role of ICPA, and how European and third states are supporting or may be supporting this effort. Please, go ahead.
Yes, thank you very much, Gabriele. Thank you very much also to Astra Institute for organizing this event. And if I may, I would like to start with using this opportunity to congratulate Frank, Elke, and Anton with this successful accomplishment of the core group, because I know personally how important and I would say crucially instrumental your role was there. So thank you very much. And returning to prosecutorial work, I would say, of course, we as prosecutors, we warmly welcome this very significant progress with the setting up of the Special Tribunal. And here, a clear framework for cooperation between national authorities and the Special Tribunal is essential, especially with regard to the collection and transfer of evidences. And here I would like to bring your attention to two key aspects, which we need very carefully to consider. First of all, this is the Special Tribunal's direct cooperation with national authorities. And second is the integration of the work of the International Center for the Prosecution of the Crime of Aggression. And in my remarks today, I will more focus on the latter, but anyway, I will cover national investigation as well. So as you know, Eurojust hosts the International Center for the Prosecution of the Crime of Aggression. It can be called ICPA or ICPA, so it depends. And it's a truly unique initiative without precedent in modern history. And in the following minutes, I hope I will provide you with some background and hopefully some understanding of the ICPA's past, present, and future, and also how its achievements will serve the future Special Tribunal. So first of all, also making some links with legal background. So as you may also recall, in March 2022, a joint investigation team, so-called JIT, was established, which is focusing on core international crimes. So the JIT consists of Ukraine, 6 EU member states, Eurojust, Europol, and also for the first time in the history, the International Criminal Court. And as Elke mentioned, indeed, from the very beginning, Ukraine, JIT countries, and also the wider international community have been discussing how to prosecute the crime of aggression. And it was also already clear from the very beginning that International Criminal Court fell outside, his jurisdiction fell outside the remit from the crime of aggression. And also, it was very clear from the very beginning that agreeing on the way forward was going to take time in which evidences could be lost or be corrupted, and still the crime was ongoing. So in this regard, and I'm also really grateful to the support of the Commission, the Commission announced its plans to establish the ICPA in February 2023. And its official launch took in July of the same year. And the legal basis for this is very classic, I would say. It's a classic European Convention of the Council of Europe of 1959. So the legal basis was there, and the ICPA was based on the JIT agreement. And the goal of the ICPA work was also very simple: make sure no time is lost in effectively preparing and contributing to future prosecutions of the crime of aggression, regardless where these prosecutions will take place. Now let's move to the present. And so today, the ICPA is a coordination platform housed at Eurojust, and it supports national investigations. This is what I was referring to, that when we speak about ICPA, we always speak about national investigations. And because it's not some kind of international organization or some separate legal entity, no, it's always investigative actions according to the national procedures and national law. So now we have, I don't know, maybe 20 prosecutors, around 20, I would say around 20 prosecutors and investigators from different countries which work at ICPA. And also we have representatives of ICC working with us and also share their knowledge, their experience with us. That is also very crucial. And now when we, I would say, covered the basics, I will refer what ICC is working on. So first of all, it's develop a common investigative framework and prosecutorial strategy. Because as was also mentioned today, that it's a very little experience of prosecuting the crime of aggression after Second World War. Second is coordinate investigative efforts and activities undertaken by each country. Third, exchange and analyze information and evidences collected so far. Fourth, prioritize future evidence collection, including types of relevant evidence in furtherance of our investigations and prosecutions. And last but not least, it's collaborate in producing joint work product. And here, as also representing Eurojust, I have to say that Eurojust supports us by ICPA team. And I'm very proud to have a very good colleagues there. And also these experts from support teams that ensures the synergy between the work of ICPA and also the activity or work related to core international crimes electronic database, so-called CSET, which was established in February 2023. So maybe it's a lot of this abbreviation, but CSET is a secure database in which we centrally preserve, store, and analyze evidences collected by national authorities. And also, ICPA benefits from, it seems small, but it's very important, administrative technical assistance from Eurojust, because, for example, as Frank said, there was some discussion even about languages. And for example, for ICPA, Eurojust ensured that there is a special working translation tool, which allows to translate from all the ICPA languages and also, of course, from Russian. Okay, and now let's look a bit into the future. So it's important to consider how the ICPA's work can be integrated into the future special tribunal. And I would say, because it's still the statute text is not disclosed, but I will say in general, first of all, it's establishing a legal framework that provides for the possibility to transfer evidence, internal work product, and operational knowledge. Second, it's allowing the internal worked products, which may also include, for example, an initial case building package prepared by the ICPA to be effectively utilized. And also, this is very important to addressing all these details in the tribunal statute to provide clarity and legal certainty. And for example, for the evidences that are stored in the CSET, the cooperation with the future tribunal was already foreseen in the CSET amendment to the Eurojust regulation in June 2022. So the articles mention, and here I will quote, that Eurojust should support member states' action in combating core-international crimes, including by making CSET evidence available to international judicial authorities. So in practice, how it might look, for Eurojust to transfer evidence to the special tribunal, two key conditions has to be met. First of all, it's authorization. So national authority that submit evidence to CSET, they remain its owners and must explicitly authorize its sharing. And second, it's legal basis for direct transfer. So the special tribunal must have international legal personality, and accordingly, the international cooperation agreement on cooperation should be done. I believe it's between the tribunal and the European Union with regard to the cooperation with Eurojust. So I would say, just to summarize, I believe this is also a very important moment for countries which are in possession of the evidences with regard to the crime of aggression, or, for example, who are investigating war crimes that might be relevant to the crime of aggression, to already consider the best way for them to transfer or to contribute to this work of the special tribunal. They can do it, for example, via Ukrainian case. They can do this via CSET, or also bilaterally with the special tribunal once it will be established. Because I believe for all of us, it's important to ensure the special tribunal becomes yet another very vital piece of the accountability puzzle. Thank you.
Thank you, Miroslava, for the practical overview, a real prosecutor's view on how things would work. But of course, having the right mechanisms is only one part of the equation. And we have learned from previous efforts that the ultimate success depends on broader questions of legitimacy, of knowledge about the proceedings at these institutions, and the context in which these mechanisms operate. And to explore these areas, I will invite Dr. Katerina Busol, Katerina, what are the key legitimacy considerations for the tribunal in Ukraine, and what are the contextual factors that you see as critical for its effectiveness? Thank you for being with us. You have the floor.
Thank you very much, dear Gabriela, and thank you very much for allowing me to join from Kyiv. And I would like to thank and congratulate Anton and his team and all the international partners who have done really the impossible work, which is at the crux of what all people in Ukraine want. Because in my remarks on the legitimacy, I will address the expectations of survivors of various atrocity crimes. I work here on the ground, and all of them feel targeted by the people who immediately raped, looted, or killed, but also by the Russian leadership who enabled all of those atrocities. Therefore, the prosecution of the crime of aggression has been the undercurrent requirement for both immediate survivors and also for the wider Ukrainian public. One of the first legitimacy consideration for the future tribunal for the Ukrainian society is that the tribunal may prosecute Russia's aggression indeed since 2014, since its beginning, and not just since the full-scale invasion. There has already been a certain frustration among survivors that certain other redress mechanisms are available only since the full-scale invasion, and obviously, especially with Russia's expansive propaganda machine, the limitation of the jurisdiction only to the full-scale invasion will create not just the distortive narrative about Russia's aims and means in Ukraine, but also may seed the divides between the already deeply harmed survivors here in Ukraine. Second, of course, it's very important for the Ukrainians and especially the survivors of war crimes, crimes against humanity, and genocidal acts that the Russian leadership, including the Troika, be prosecuted. Now, we've heard from the colleagues that there may be legal limitations on the prosecution depending on the tribunal's modality and depending on how much of the international support it gains. What is crucial here is to have a very targeted and timely and preemptive information campaign and public awareness campaign to explain it to the Ukrainian public why the tribunal's jurisdiction and reach with respect to President Putin and Mr. Lavrov and Mishustin is the way it is under the current statutory framework. The next legitimacy consideration is indeed victim participation. And it would be really important to engage survivors of different backgrounds, depending on their sex, gender, sexual orientation, religion, civic activism, and social background, to explain the way not just the immediate war crimes or crimes against humanity or alleged genocidal acts have harmed them, but indeed how the wider evils of aggression have reverberated with them. And through such engagement, which I understand is not easy and is not unproblematic procedurally, and we have heard that from the colleagues already, but through such an engagement, the tribunal also has the potential to really explain the individual harms of the crime of aggression, which historically has been considered as an encroachment of a state against the state. But the tribunal will have the unique stand-in to explain how the crime of aggression affects individual lives and the lives of the communities, even of those persons who have not necessarily been affected by immediate war crimes, crimes against humanity, or genocidal acts. It's also very important for not just the judges and the prosecutor within the tribunal, but indeed the staff of all levels to have the strong regional expertise, the strong knowledge of the history of Central and Eastern Europe, and indeed the legacy, the imperial legacy of Russia's oppression, be that the Imperial Russia, Soviet Russia, or nowadays Russia, because it would really give the nuanced historical background and understanding of the means, methods, and ultimate aims of Russia's ongoing aggression. And to conclude, I would like to also stress the need for the targeted and preemptive strategic communication, public outreach regarding the in absentia proceedings and the right to appeal. Indeed, in Ukraine, the majority of conflict-related proceedings are being held in absentia. But of course, the public imagery in the country is seeing President Putin in the dock in The Hague. So again, it would be really important to understand for the society to understand the limitations on having that, perhaps the stages when the person can be taken, as well as why it's crucial for the rule of law, for the legitimacy of the tribunal internationally, to ensure the right to appeal, which we have not seen in Nuremberg and in Tokyo. These are all major remarks from me now. I'd be happy to respond to further questions. Thank you.
Thank you. Thank you to all five of our distinguished panelists, Anton, Frank, Carolina, Miroslava, and Katerina, for the excellent presentations and answers to the questions that I had. And we've covered remarkable ground today, from the core group's work to the importance of accountability for the crime of aggression, to the Council of Europe-Ukraine model, through immunity challenges, cooperation mechanisms, to the crucial elements of legitimacy and effectiveness as perceived in the countries where it matters.